good afternoon and welcome to the sixth session in our Leasehold Knowledge Week. And we are going to be discussing the do's and don'ts of reading a lease with Yashmin Mistry, partner at JPC. Yashmin is an award-winning and industry-renowned solicitor, and as a partner heads up the JPC's real estate team. She's respected and known both for her in-depth understanding of complex enfranchisement matters. She's an equity partner, owner of the firm, and Yashmin consistently delivers expertise around her niche area of leasehold enfranchisement, ensuring the department sustains its reputation as leaders in its field. So I'm going to hand over to Yashmin. Please make sure that you submit as many questions as possible throughout the session. We'll be answering questions during and at the end. So make the most use of Yashmin while she's around. Hello, Yashmin. How are you today?
Hi, how are you? I'm good, thank you. Charlotte, how are you?
Very well. I'm very well indeed. But I'm going to turn my camera off now and I'm going to hand over to you. But I might interject with some questions. All right.
Perfect. Thank you very much. Good afternoon, ladies and gentlemen, and welcome to today's webinar or seminar talk on what to or how to go about reading the lease. Apologies, it's not the same as usual because for those of you that are used to my normal sessions, there's normally chocolate being thrown at you and bottles of Prosecco. So I can't really replicate that over the virtual web, but we'll try to, cover what you need to know about leases effectively over the course of the next 50 to 60 minutes or so. We want it to be as interactive as possible. So, send through your questions. There's two ways in which you can send through questions. The first way is via the question and answer session. The question and answer box, which is at the bottom of your screen. And then there's also the chat box, which you can send through questions. I'm happy to deal with questions as we go along because I'm conscious that me talking at you for 50 minutes or so is just going to be boring. So send through your questions and we can deal with them as and when we go along. Charlotte can read them out, or I can actually see them as well. First bit of technology, hopefully it will work. I've got to share my screen with you, which I'm just about to do. Hopefully you can all see that, can you? And for those of you that are listening, just to assure Vicky and Charlotte that they're not listening just to me, if you start typing into the question and answer box or the chat box, just your name, where you're from, and we can just give you out a shout out. And if you've got any questions now, please do start sending them through. So I think people are typing, but feel free to continue typing through. You should hopefully also be able to see the screen with my slides, and let's start then. Okay, so understanding the residential long lease. Is moving? Yes, okay, so different types of structures. So generally, I'm sure you're aware there's three types of ways in which land or tenure can be held in England and Wales. The first one is freehold, the second one leasehold, and the third one common hold. I'm sure you've all heard of those three different types of structures. Leasehold and common hold, obviously in the press a lot recently, or over the last couple of years, especially with the Law Commission's work into common hold, and also the looking into the reforms of leasehold effectively. It's leasehold that we're going to touch upon in this webinar, and that's what we're going to focus on. So those are the structures. In terms of the different types of tenures, you've also got, apart from the way in which land is held, leasehold becomes slightly more complicated in that there's other structures that both go vertically and horizontally, which you need to be aware of. So title structure, when you're approaching a question or you're thrown something from one of your blocks, or you come across something in practice as property managers, the first thing to understand is who is your client and what their responsibilities are under the leases. And from there, you can then, put together the answer or try to attempt to work out what the answer is. And the reason why that's important to understand is because under the terms of the leases, you need to understand essentially whether your client is the management company, whether it's the freehold company, or whether it's actually an intermediate title. And things like understanding intermediate titles and how titles are structured really comes down to things like looking at licenses, where you've got a leaseholder who's made an application for, say, a license for alterations under a lease. You need to understand whether consent should be provided by the landlord, or whether it should be provided by the management company. But more so, you also need to understand whether your client is the freeholder or the landlord that can give that consent, or in fact whether there's an intermediate landlord that you, or a landlord above your client, that needs to give that consent. So you've got the freehold, you've got intermediate titles, you've got management companies, and sometimes also you've got right to manage companies which sit outside all of that. And right to manage companies are where leaseholders have got together as a collective effectively, and they have formed a special kind of vehicle which is called a right to manage company. They've gone through a process and then taken over essentially the management functions under the terms of the lease. So anytime that you approach me, and when I'm approached by clients to ask a question, or someone who asks me a question, the first thing that I will always ask is, can I have a copy of the lease, and who is your client? So let's see if we can move across slightly to the slide. Sorry. So what is a lease? Leasehold. Lease. People get their well, they get into a pickle when they have bought a lease, essentially, but a leasehold property. But essentially, what leaseholders need to understand, and what you need to understand when you're dealing with leasehold, is that a leasehold property gives a leaseholder, or the owner of that property, the right to use and enjoy that property for a defined period of time. And the document that governs their use effectively of that property is called the lease. And essentially, therefore, the lease is basically the contract under which the property is held. That's different to an AST or in a short hold tenancy. That in that situation, the tenant doesn't have any security of tenure, or they don't have a property interest. However, with a lease, you have got the lease, which is effectively the contract. And this is what I keep saying when I'm approached by leaseholders with or property managers with questions. The first thing that we'll ask is, what does the lease say? Because essentially that's the contract that you need to keep going back to. So a lease is a legal term. It essentially records the agreement which has been reached between the parties. Normally, there's, a lease can be drawn in 2 or 3 ways. The first way is the most simple way, which is between 2 parties, which is the landlord and the leaseholder. However, you do have leases which are, and probably most of the leases that you guys deal with out there, you have tripartite leases, and they are leases which are drawn between 2 or more parties. So in those kind of situations, it's normally the landlord, a management company, and the leaseholder who are party to those leases, and those leases are called tripartite leases. And essentially, leaseholders, when they're entering into negotiations over what the terms of the lease should say, as usual, leaseholders generally have very little bargaining power, because essentially when a lease is first granted by a developer or a landlord, for example, essentially the landlord will just basically set out the standard form of lease for that development, and they won't really accept any amendments to it apart from obvious errors and that kind of thing. So that's essentially what a lease is. Do keep sending through your questions if you do have any, because it will be we can deal with any questions as and when we go through. So a premium is paid, or a capital sum is paid for the property, and that is called the premium. And that premium is paid for essentially the exclusive right or the exclusive use of that property for a defined period of time. The lease will also set out, and we'll look at that as we go through the next hour or so, but there's other things that will be payable under the lease. So there'll be things like ground rent, there'll be service charges, which are all different, and we'll look at what those mean as we go along. And how they're paid and when they're paid in terms of ground rents and service charges, they will be determined by the lease. So again, it's always coming back to the contract, and the contract is the lease when we're dealing with leasehold property. So looking at the key parts of the lease, unfortunately, I know you all want me to say, is there a single, the usual question is, these leases are all different. All of the leases say different things. Unfortunately, there is no single format, and the reason being is that each block is different, and therefore it's not possible to have one lease which fits every kind of situation in every kind of block. The Land Registry did look into having one single format a little while ago now, but they just decided it was simply not a feasible task to draw up one pro forma lease for all buildings that could be used across. I mean, in some ways it could have made life simpler, but then your life wouldn't be fun as property managers when you're dealing with questions on a day-to-day basis. Although, now I say there's no single format, but leases generally are based in a similar or broadly similar layouts effectively, and we'll look at how leases are generally set out and the process for those. And since the 19th of June 2006, the Land Registry has now said that all new leases that are granted after this date have to contain something which is called prescribed clauses. And prescribed clauses are essentially a summary of the key terms of the lease, and they're normally contained in a table essentially at the beginning of the lease. It's normally an LR 1 to 14, and it just sets out the summary. So it sets out the key parties to the lease, the term, the premium that's being paid, and it sets out some other things as to how the property is being held, whether it's joint tenants, tenants in common, whether there's any restrictions against the title that you need to be aware of, and all of those things. So those are the prescribed clauses, are essentially at the beginning of the lease.
Now I've got two questions, Yashmin. Do you want to answer any questions?
Yes, we can answer two questions.
Okay, so Graham has said, with the proposals by the government to the changes in the enfranchisement legislation, what do you think the times will be for getting into Parliament and becoming law? And also, do you think it will stay as proposed with abolishing marriage value? And will they look to make changes to other things, such as reducing the deferment rate or applying a percentage on development or hope value? That's the first question.
Okay.
Nice small one for you there.
Thanks for that. So just taking that in stages, I think, because I haven't got a very good memory, sorry. So the first bit is, how long do we think it will take to get to Parliament? Is that correct?
Yes.
In terms of the new reforms. A good question. The problem with the announcement that was made in January or early this year is that it didn't really give us anything. So there was this massive announcement, but there was nothing, there was no meat on the bones effectively. So essentially, being in the industry, having the talks in the industry, we're probably looking, well, I think personally, 3 to 5 years before we see any particular changes. And what those changes are, we don't really know. Yes, there's this big thing that marriage value is going to be abolished. But the question really is, until we see the draft legislation that's being put before Parliament, we're not really going to know what that means. Is it that they, whilst on one hand they abolish marriage value, but they tweak with the formula slightly, so it compensates for the marriage value. The other thing that the government really haven't banked on is whether the landed estates really are going to challenge this. And I guess we're not going to know whether the big landlords or the landed estates are going to challenge it until we get some more information about what it actually means, if that makes sense. So I hope that answers both questions, actually. Does it, Charlotte?
That answers Graham's little question. I've got a question from Amy saying she apologises foolishly to see if this is an easy question, but she said she's currently training to be a property manager. Who is it that writes the lease, and will it be written by a developer, or is it written by a developer?
The developers will appoint their solicitors. So it will be the solicitors that will be writing the lease on behalf of the landlord or the developer. And essentially what happens in practice is that the landlord solicitor will draft the lease, send it to the leaseholder, and there'll be very few amendments that they will accept. Unless there's obviously, as I said, I think before, if there's, you know, blatant errors or the lease is quite frankly wrong in terms of drafting. Now, the problem with leases is that they're just generally always badly drafted. One of the reasons is that solicitors don't actually go to the properties, or they don't see the properties themselves, or they use precedents. And, you know, I'm a solicitor as well, but yeah, we use precedents and we just keep copying and pasting, so that effectively the mistakes repeat themselves effectively. And you need solicitors that actually think about what they're doing, apply leases to actually what's there on the ground. So does that answer your question, Amy? I hope so.
I think that was a great answer. So thank you very much. I'm going to turn myself off again now.
Okay, all right, thank you. Okay, so a format of a lease. Generally, leases will take the same kind of format. So at the beginning will be the date of the lease, and that date of the lease is the date that it was completed. So the first thing that you normally see is that this lease is dated, I don't know, the 1st of January 1980. That date is the date that the lease was completed. So essentially the date that the premium was paid and the leasehold property was purchased. That date, or the date that the lease was completed, may not necessarily be the same date that the lease commences from. So sometimes you see the lease was dated the 1st of January 1980, but if you read down and you go to the ground rent provisions, it will say, or somewhere near the ground rent provisions, it will say that the lease is for 99 years from the 1st of January 1978, for example. So those two dates are very different. The completion date at the top of the lease, at the front, at the beginning of the lease, and the date of commencement. And the date of commencement is important because the things and the obligations from which are contained in the lease essentially start from the date of the commencement of the lease. So the year, the ground rent, all of those things, the cyclical repairing obligations under the lease will start from the date of the commencement of the lease rather than the date that the lease was completed. So I hope that sometimes I get asked questions by property managers why are there two different dates in leases. So you've got the date of the lease, and then usually you will then see the parties. Now, whether that's two different parties or three different parties or four different parties, they should normally be named at the beginning. And obviously with the newer leases, which were granted after 2006, the prescribed clauses, one of the questions in the prescribed clauses is name the parties in the lease. So it's quite an easy and quick summary to go to the prescribed clauses. Otherwise, if it's an older type of lease, it would be normally at the top or at the beginning that the lease is drawn between these parties. Leases then generally go on to definitions and interpretations. So what is the demised premises? What's the flat? What are the common parts? What are the reserved parts? There'll be definitions under the parties effectively. You'll then have the operative parts, and by operative parts I mean the main chunky bit, so the leaseholder's obligations and the landlord's obligations, and if it's a tri-party lease, the management company's obligations. And then some leases will have schedules, so the schedules will deal with defining the property, defining the reserve property, so property which is retained by the landlord. It will then go into maybe a service charge schedules, and then you've got the rules and regulations, which is another schedule. So some leases have schedules, some leases don't, or where leases don't have schedules, those bits will be built into the main part of the lease essentially. So don't worry, the lease is not defective if it doesn't have a schedule. We've kind of touched upon this slide, parts of the parties to the lease. As I said, whenever I'm approached by a property manager with a question, the first thing I will, well, there's two things that we'll ask. Please, may I have a copy of the lease, and who is the client? Because again, it's important to understand when you're faced with the question who your client is, so you can work out what the responsibilities are. So it could be the landlord, the lessee, the management company, the right to manage company, or you could in some instances be acting for either a right to manage company or a head landlord or an under lessee, etc., etc. So really important, first thing as property managers, understand who your client is. Term of lease. So lots of leases have different terms. The usual ones that we normally see are 99 years, 999 years, 125 years. As I've seen some for 135 years. I don't know whether that was just a typo. It was meant to be 125 years, but there was a typo in it. I'm not quite sure why that was there. But those are generally the lease or the different lease lengths that you will see. That's not to say that you can't create a lease for, I don't know, 59 years. It's entirely up to the landlord as to how much of a lease that they want to grant, essentially. What happens when the lease expires? Essentially the property will revert back to the freeholder or the landlord, essentially. But if you're a leaseholder, don't panic, because you can still hold over essentially until the lease is extended or a new lease is granted, and you hold over as an assured tenant rather than a leaseholder at that point, and you then pay market rent essentially for staying in that property. A lot of leaseholders will extend their leases, obviously, before it gets to running out, essentially. And I remember a horror story where I was instructed on a lease extension, probably about 4 years ago now, and there were 3 weeks to run on the lease before it expired, and I was instructed to serve notice. That was very, very scary in terms of serving a lease extension notice, because essentially if I'd got the notice wrong, the lease would have expired, and with 3 years to go, we were very, very careful in terms of what we were checking in terms of our notice at that point. So that's term of lease. If you've got any questions on that, obviously do send them through.
There is one question.
Okay.
On what is the interpretation clause. I know you briefly touched on that 2 slides ago, but I didn't want to interrupt you.
Oh, okay, sorry. So interpretations are definitions. So sometimes a lease will, instead of, it will define a lease, it will define a term. So it will say the flat means, I don't know, the ground floor flat at, numbered 15 at the block. So rather than then having to repeat the description of the flat, essentially, it's just then defined as flat, and ground rent will be defined. Those are the things. So it's essentially a key at the beginning which defines the terms that have been defined in the lease, so you don't have to keep repeating it. So, does that answer your question?
Okay. I think that answers the question. I've got one more.
Okay.
How long does it, I've got 2 actually. How long does it take to get a lease extension from start to finish?
Well, there's 2 ways in which you can extend leases. The first one is a voluntary deal. So you go to the landlord and you say, please, can you grant me a lease extension? And you are entirely at the goodwill of the landlord. He may turn around and say, yes, I'm very happy to grant you a lease extension, or he may turn around and say no, or he'll string you along, etc., etc. So that's one way, which is a voluntary deal. If you do get a voluntary deal done, it can take as long or as short as both parties are working at it, or whether the landlord gives you a deadline to complete a lease extension, it could take that long. In terms of the statutory process, it's quite a long drawn out process, and essentially you're probably looking at between 6 to 9 months on average, excluding any applications that may or may not have to be made to the tribunal. So in terms of the statutory process, minimum 6, maximum, if we're going to the tribunal at this precise moment, you're probably looking at about 12 to to 14, 15 months essentially for the lease extension process.
Okay, I've got a question saying, sorry, I missed the first 5 minutes. You might have covered this. I'm a director of a residence management company, an RMC, as well as a lessee, as I own a property managed through the RMC by a managing agent. Who is considered the landlord? Is it the freeholder of the estate, or is it the director of the RMC? Our lease doesn't make it quite clear.
Okay, on that specific one, I probably have to look at the lease. Essentially, it sounds like I need some more details, but if the lease is drawn between 3 parties, so that's the landlord management company, which is a lessee owned management company, and the leaseholder, then in that kind of normal situation, without looking at the lease, but in a normal situation, the management company would be responsible for the management of the development or the building or the estate, and the landlord generally would be responsible for collecting the ground rents if there are any under the terms of the lease, maybe insurance, or they may have passed that on to the landlord, onto the management company, and they may have retained some other rights in relation to the bigger or wider estate as landlord. But on that specific question, I think we probably would have to look at the lease and give you some advice specifically on the question there.
Okay, I've got one more. Does an expired lease automatically go to a short hold tenancy? Is this indefinite if the lease isn't extended?
If the lease expires without it having been extended, then yes, it turns into a tenancy, and you pay market rent for that. And then obviously it's conversations with the landlord in relation to what's going to happen next, if that makes sense. So you won't be thrown out, you can still stay there, but obviously it's not ideal. It's not an ideal situation, and you would definitely, I mean, we would always recommend people extend their leases before they drop below 80 years, but definitely before they expire. So yeah. Okay,
perfect. I'll let you get on.
Lovely. Sorry, I'm thinking of time because I think we're at the halfway mark, possibly, are we?
Correct.
Okay, all right, let's talk. So ground rent. What is ground rent? Ground rent is is compensation payable for the freeholder. It's not, as I said before, it's not to be confused with service charges. Service charges and ground rents are 2 different things under the leases. In this particular instance, we're talking about ground rents. And how and when and how it's demanded will be set out in the actual lease. So you'll have to read the lease to work out, as landlord or management company, whether you're demanding it, and who and how and what the lease says in relation to it. Usually ground rent is a nominal amount, so it's 10, 50, £100, maybe £200. It can either be fixed for the whole of the term, so it's £100 for the whole of the term. It could be reviewed, so it could double, or it could, another way in which ground rent is reviewed is that in the first 33 years of the term, it's X amount. In the second 33 years of the term, it's another amount, and for the rest of the term, it's something else. Or it could be reviewed by reference to RPI or something like that. You just have to look at the lease to work out whether or not or how ground rent should be demanded or charged, essentially, and whether there's any review periods. One thing here is that if you are instructed as property managers on behalf of the landlord, and you take on a new block, or just generally in terms of all your blocks that you're dealing with, the one thing to do is obviously check the ground rent provisions to see whether there is changes to the ground rent and how those changes are, and diarise those ahead. Because what you don't want to do for a landlord is let a rent review date pass, because essentially the landlord's going to come after you probably for any rent or ground rents that you've missed as part of the rent review. Now, some of the older leases will say in relation to ground rents that ground rents are payable whether they're formally demanded or not. Since the 28th of February 2005, that regardless of what the lease says in terms of ground rent is due and payable regardless of whether it's demanded, it now has to be demanded, and there's a prescribed form for demanded ground rent And essentially, if it's not being demanded correctly in line with the lease and in the prescribed form, then ground rent essentially is not payable until that's been remedied effectively. So really important that if you are issuing ground rent on behalf of your ground rent demands on behalf of your client, that you've got it in the prescribed form, and it contain the prescribed clause also has to follow with it the notes which are part of the prescribed form essentially. For leaseholders, if they don't pay their ground rents, they're potentially liable to have their leases forfeited. So yeah, I mean, it's really important that ground rent is paid. Extent of property, the lease should define the extent of property which has been demised, one, to the leaseholder, and two, the parts that are retained by the landlord under the terms of the lease. The most common area or areas that we have issues or I'm approached with questions about is windows, flats, doors to flats and balconies. And in theory, the lease should set out who's responsible for what part, whether the windows are retained by the landlord or whether the doors are retained by the leaseholder, or whether the balconies, what parts of the balcony are retained by the landlord and which parts are responsible for the leaseholder. I know that a lot of leases are either silent or very muddied in relation to what parts of the window or doors or balconies are retained. In that situation, I mean, I've dealt with leases where they're either quiet, they're either silent on the position, or it's kind of woolly and it's not really clear. In that situation, what we would have to do, and what any tribunal would do, is that it will be a process of elimination and a process of interpretation, essentially, as to come to the conclusion or the answer. One application where leases are not particularly clear on the landlord's responsibility in relation to particular parts of the property. One kind of application that's not really used very much by property managers or landlords at all is the ability to make an application to the tribunal under section 27. And that basically, essentially, you make an application to the tribunal, it can be done by paper, and you basically say to the tribunal, this is my lease, this is what I potentially want to charge for under the service charge. Can you please tell me or give me a determination as to whether you think the landlord is responsible for it, and if they are responsible for it, whether it can be put through the service charge. I don't see that application being used nearly enough as I thought it would be by landlords and property managers. And just last week, I had a similar situation where I was asked a question to provide advice in relation to the balconies. Unfortunately, the lease was completely silent in relation to responsibilities for balconies. It was, there was something there, but my advice in that situation was just to be absolutely clear and to get a determination from a tribunal, make the application. So in theory, the lease or the contract should set out what has been demised to the leaseholder and what's been retained by the landlord. It's not, I mean, leases are just generally very poorly drafted. So consider making those kind of applications. Rights. The leases also contain a section, whether that's at the beginning or whether it's in a schedule, effectively rights holders. Now, rights are things such as rights of way to walk over the communal parts, rights of parking, rights of conduits, so the services can pass between flats, maintenance, protection, etc. So, they're there, they're contained in there. And similarly, the lease should contain reserved rights for the landlord, just so the landlord has the ability to maybe access the common parts of different flats to be able to keep up with their maintenance obligations under the terms of the lease. Some leases which have been drafted by developers will contain rights to redevelop, so that's the landlord's ability to be able to chop and change parts of the estate or parts of the development with, in different ways. So they could move the car park, or they could move the gardens, or things like that. So if you're acting for a landlord as a property manager, always important to check rights of development to see whether the landlord has reserved themselves the ability to be able to chop and change parts of the estate. Covenants by the leaseholder. So the lease will deal with covenants by the leaseholder. What are covenants? Covenants are essentially promises. That's all it is. A promise by the leaseholder to do something. So the usual things that the leaseholder will promise to do under the terms of the lease are pay the payments. So it's to pay the rent, to pay the service charges, and some leases will have the obligation for the leaseholder to pay costs. So that's cost of the accountants or the auditors to put together the service charge accounts effectively, or the cost of an on-site caretaker, all of those kind of costs, the uniform costs of staff on site. It will have those kind of obligations within, and they will be contained within the leaseholder's covenants. There'll also be the covenant for the leaseholder to maintain and repair their property. And sometimes with masonette leases, there'll also be this really weird obligation for each masonette owner. So the top floor, a masonette with the usual standard top, bottom and top, each flat having to take out their own buildings insurance. So yeah, it may contain the leaseholder's obligation to take out their own insurance. It will also contain some obligations on the landlord as to alterations. So the alterations provisions are important, and that's something as property managers you probably deal with on quite a regular basis. Whether the leaseholder has to get consent for internal works, external works, whether consent has to be obtained at all, or whether there is a complete prohibition from alterations. Absolutely. So again, really important to check the alterations provisions. And then following on from that, and I said it at the beginning, I keep saying it, it's really important to check who that consent should be obtained from. The reason I'm asking, and then it comes back to who your client is that some leases will say that alterations consent should be obtained by the management company. But if you're acting for the landlord, you obviously can't give that consent. The leaseholder has to obtain that consent from the management company. So again, really important, two things: check what the lease says and check who your client is, and see whether they've actually got the ability to provide that consent. The same thing applies to sales and sublettings and the assignment provisions. So whether a license to assign is required or whether it's just a deed of covenant on any sales. Again, always important to check the lease, what those requirements are in the first place, and who can provide any consents that are required under there. And then user. The user covenant in residential leases is usually to own or use the property as a residential lease. Rather than, I don't know, I mean, last week I had a flat which had been turned into a pole dancing club. So, there's all sorts of weird and wonderful ways in which flats are being used at the moment. And more, it's really quite important at the moment in terms of that user provision. I know whilst we're all locked down, we don't have a choice, everyone's staying at home in their flats. But one question I've been asked more and more recently, and with working practices actually changing going forward, is that will people start working from home more, and is that permitted under the user covenant under the terms of the lease? So if you're acting for landlords, management companies, it's something to consider, and it may be something that you actually need advice on in terms of going forward, or some kind of policy within your block, essentially. Sorry, just looking at the time, I think we've still got time, haven't we, Charlotte? Oh, yes.
Oh, yes, we've still got time. You've got 20 minutes.
Perfect.
I've got one question. Someone asked, can the landlord put up ground rents?
Well, it depends on what the lease says. So if the lease says, for the remainder, for the term, the ground rent is £100, then no, the landlord can't put it up. However, if the lease is got a review mechanism in there, you have to look at the review mechanism to see whether or not and when the ground rents can be amended. Sometimes, as I said, the lease will say that for the first X amount of years, the ground rent will be X, and then for the next amount of years, it will be Y. But some ground rents, some leases will refer to review provisions, and those review provisions have to be read and implemented essentially. So hopefully that answers that question.
I've got one more. If percentage contributions have been charged incorrectly, should this be backdated and the leaseholders credited / debited, and how many years should it get backdated?
Okay, interesting question, and it really depends on how the lease has been drafted, and what it says in relation to service charge provision. So I think that's quite a specific question, and probably something that we need to deal with offline.
Okay, and somebody asked, why is ground rent charged by a landlord rather than a managing agent?
Well, essentially, the managing agent is an agent on behalf of either the landlord or the management company. So it will be demanded by the landlord, and it will be, well, the notices will go out in the name of the landlord. However, that, you know, the landlord could delegate that collection process essentially to the managing agent. So does that make, hopefully that answers that question.
Lovely. Okay, I'll let you get on.
Okay, lovely. Okay, who's responsible for repairs under leases? Again, it's a question that we're normally asked quite a lot. So I will be asked who's responsible for maintaining the balconies, or who's responsible for, I don't know, the common parts. Again, it's a commonly misunderstood or a ground for contention between leaseholder and landlord, or management company, essentially. So as with all of these things, it's really important to go back to the lease, look at who's responsible for what, and then you can then attempt to answer the question. Now, just because a lease has been drafted doesn't mean that the lease will contain all sorts of management obligations. Now, by that, I mean, well, I say recently, about a month ago, I was asked to advise in relation to maintenance of some garages at a development. Now, when I looked at the lease, it was quite clear that the leases didn't really deal with the garages at all. So the leaseholders were not responsible and the landlord was not responsible. And what was happening in that situation was the landlord was obviously assuming responsibility for maintaining the garages and charging that through the service charge. But actually, if you looked at the terms of the lease, they didn't actually have the obligation to do that in the first instance. And secondly, it then followed that because the leaseholder, because the service charge provisions under the lease, or the mechanism, didn't allow those costs to be recovered, then actually they were charging for monies that they couldn't actually put through the service charge under the terms of the lease. In that situation, we actually probably have to make an application to vary those leases, because the development, someone needs to quite obviously needs to maintain the garages. So again, really important, don't just assume that the structure will be the landlord's responsibility, the common parts will be the landlord's responsibility, the windows will be the leaseholder's responsibility, and the communal pipes will be the landlord's responsibilities. Really important to check the leases just to make sure that the leases contain the provisions in there. And then the second part of that is that the service charge allows you to recover those costs, because it doesn't always follow. In relation to pipes, the thing that we normally get asked about is whether the leaseholder is responsible for the pipes or whether the landlord is responsible for the pipes. Again, each lease is distinct and separate, and they have to be checked individually on a case-by-case basis. But the general provision will be, or the general understanding, or the way that these things normally work, is that where a pipe exclusively serves one premises, then that pipe is generally that leaseholder's responsibility. Where a pipe serves more than one property, then essentially that pipe will be a communal pipe. But again, really, really important to check the terms of the lease in the particular block that you're talking about and where you've got the issue with. Landlord's covenants. So we've dealt with leaseholders' covenants, landlord's covenants. Again, should deal with things like buildings insurance. So the landlord's obligation to place the insurance, the landlord's obligation to repair the building. And one that's really interesting is the enforcement of covenants in leases against other leaseholders. So this is the provision where the leaseholder has the ability to ask the landlord to enforce covenants. Because if you think about it, a lease is just a contract between a landlord and a leaseholder. Leaseholders don't have contracts with each other, essentially. So if leaseholder A is breaching the terms of the lease, leaseholder B can't take any action against leaseholder A themselves because there's no contract between them, or there's no privity of contract. So all leaseholder B is left in a position of doing is petitioning the landlord with which he's got a contract, and asking the landlord to enforce the covenants against the leaseholder A under the terms of their contract, which is the lease for flat A, essentially. Now, that's the reason why those provisions were put in leases. And what landlords can do just to ensure that they don't get into personal battles between leaseholders, essentially, is that the clause, if you look at it, should normally will have the ability of the landlord to ask the leaseholder who is complaining and requesting the enforcement of the covenants against the other flat, to put down some kind of security. And security in this the context essentially means paying the landlord's costs for enforcing the breach of lease terms, or the alleged breach of lease terms, if that makes sense. So that's quite a useful tool when leaseholders are complaining about other leaseholders being in breach of their lease. And what we tend to find is when the landlord does ask for security, if it isn't a massive issue, that problem doesn't really become an issue, because essentially the leaseholder who's complaining doesn't want to put their hand in their pocket to provide the landlord with the security of costs effectively in that situation. So that's an enforcement of covenants. Peaceful enjoyment, it's not, I mean, it doesn't relate to the leaseholder being able or living in the flat in absolute silence. This relates to effectively the use or the landlord not stopping the leaseholder from using the property. So the landlord can't put up scaffolding, say, in front of the doors. They can't cut off people's fobs for car parks and entrances to buildings, etc., etc. So that relates to the use, the leaseholder's use of the property, rather than quiet and noise and that kind of thing. Service charges, we've touched on this slightly. Again, it's different to ground rents. Service charges are essentially the contributions that the leaseholders make towards the maintenance of the common parts. And it's really important to check your service charge provisions to see what can and cannot be put through the service charges. The leases should be clear on what you can and cannot put through. Things where we normally get asked are reserve funds and sinking funds. Essentially, I mean, technically there's a difference, but essentially in this kind of context, they're both classed the same. It's essentially a fund or a surplus of money that's collected in advance to ensure that things like lifts and buildings and roofs can be dealt with, essentially. Really important to check your lease terms, because we have property managers or landlords, management companies that are collecting reserve funds, but actually when you look at the lease terms, they have no rights under the leases to collect reserve funds. So essentially in those kind of situations, unless the lease allows you to collect a reserve fund, you can't, or you shouldn't technically be collecting monies in respect of reserve funds. So again, look at that. The service charge provisions, whether that's in the main body of the lease or in the schedules, will also talk through or deal with how the accounts should be dealt with, whether advance or one-off payments can be collected through the lease term. So service charges are normally paid quarterly, 6 monthly in advance. There are some leases out there, I don't know how these operate, or as property managers you operate with these, where service charges are payable in arrears. So essentially in that kind of situation, the landlord has to incur, or the management company has to incur all the costs of the service charge year, and then the leaseholder at the end, once those costs have been incurred at the end of the year, then pays the service charge on demand. Again, really important to check your lease whether you've got the ability to charge in advance, and if you do have the ability to charge in advance, how regularly you can do that, and whether or not you can or cannot charge for one-off payments. There's very few leases out there which allow the landlords to charge for one-off payments, but there are leases out there. Regulations are the things that, the usual things are the leaseholder can't use the balcony, satellite dishes can't be put up, wooden flooring, loud noise, music, all of those kind of things. Those are the things that are normally dealt with in the regulations. And again, they'll either be in a separate section or schedule at the end of the lease, or they'll be built into the main body of the lease. Losing your lease, we're nearly there, guys. Losing your lease, forfeiture. Very long and protracted these days. You have to get it determined before by a court or a tribunal, or the leaseholder has to admit to the breach before you can serve a Section 146 notice. And once you've served the Section 146 notice, you can then start county court proceedings effectively. It's a very long and complicated process these days. So yeah, that's how you would get rid of your lease, or essentially forfeiture. So I think that's it. Charlotte, do you have any questions? Or
Oh, I certainly do.
Okay.
I certainly have some questions. So what happens if the lease is silent on the collection of a reserve fund?
Okay, if a lease is silent on a collection of a reserve fund, it means that you're not entitled to collect one. So yeah, unfortunately, in that situation, you probably, it makes sense to collect a reserve fund, and I can't see how any leaseholders wouldn't want the ability to collect a reserve fund on the basis that it just helps with cash flow, personal planning, finances, all of that kind of thing. In that situation, if the lease is silent, unfortunately can't collect it, you can then, what are your options? You can make an application to have the leases varied to permit the reserve fund to be collected. Now, in terms of amending leases, you can't amend people's leases without their consent. And in this kind of situation, you would want, or you would hope, all the leases to be amended in the same form. So either you do it voluntarily, everyone signs up, or the other option is to make an application possibly to the tribunal under one of the grounds. But again, we would maybe need to have a more detailed conversation about that.
Okay, I've got another question. Does the developer always have the right to appoint a managing agent? If there's a tri-party lease, how can you work out chain of communications, i.e. who speaks to what party?
Okay, so first question, sorry, question was, does the lease always...
Developer always have the right to appoint a managing agent?
Any party to the lease can appoint whoever they want. The question really, I think, is if a managing agent is appointed, can the costs of the managing agent, the management fee, be put through the service charge? Again, in that particular lease, you would have to look at the lease provisions to see whether the service charge enables the cost of management, whether that's managing agents or the landlords doing management themselves, to be put through the service charge. So I think that should answer that question. In terms of the second question, it was chain of command, I think.
Yeah, if there's a tri-party lease, how can you work out the chain of communications, i.e. who speaks to which party? Okay.
Ideally, the landlord may or may not appoint their managing agents. The management company may or may not appoint their managing agents. If both parties, so if the landlord appoints their own managing agents and the management company, which is party to the lease, appoints their managing agents, in an ideal world and an ideal situation, there should be some kind of communication between the landlord's managing agents and the management company's managing agents in relation to simple things. So for, assignments, if flats are being bought or sold in the property, it will be useful when the notices of transfer or assignment is served on the management company's managing agents. They communicate that with the freeholders, agents or solicitors, so the landlord knows who to demand their ground rents, and vice versa. So if the landlord is served with a notice, then obviously they communicate with the managing agents. Again, this is all about communication and good planning, essentially, in terms of the estate and good estate management principles. I know that doesn't work all the time because of personalities, just because you don't know who they are. So yeah, it depends on the managing agents and whether they're willing to communicate with each other, essentially. But as leaseholders, the leaseholders would generally, I presume, just communicate with the managing agent appointed on behalf of the management company, because they will probably, under the lease, have the day-to-day responsibilities for dealing with management.
Okay, I've got two more questions. One, I'll give you them both and you can answer them. One, what can I do if the landlord breaches the terms of my lease? That's the first question. And the second one, a doubling ground rent clause is blocking sales. What can be done? What is likely to happen, re the government review, and what timescale do you envisage? I think we sort of did some of that earlier.
Yeah, okay, so doubling ground rents. Just because a ground rent doubles doesn't necessarily mean that it's an onerous ground rent. So you need to look at the lease to see what the doubling ground rent means and whether or not it's onerous. If it is deemed to be onerous, you can either approach the landlord and say, would you be willing to grant me a deed of variation, possibly, or a lease extension to get rid of the ground rent provisions, and see whether they're willing to do that. If they're not, the only thing that you can do to buy out the ground rents, essentially, would be to serve a statutory lease extension notice. The reason why you would serve a statutory lease extension notice is that once you serve a statutory lease extension notice, you're entitled to three things. So you're entitled to a 90-year lease extension. You're entitled to a lease on exactly the same terms as that which you've got at the moment, subject to minor amendments which are permitted under the legislation. But more importantly, you're entitled to a new lease or a 90-year lease extension, and the ground rents get reduced to a peppercorn from completion of that lease extension. Now, obviously, I understand that you have to pay out those ground rents as part of the lease extension process. But if there's sales in the development, it may be that it's tied in with the conveyancing process. So essentially, if a leaseholder has held their lease for more than 2 years, the seller can serve the lease extension notice and assign the benefit over to the purchaser, who will then complete the lease extension process. So that may be a way round it. In terms of the legislation, I think we touched upon it right at the beginning. Best guess 3 to 5 years before we see any particular changes. But again, we're guided by the government in terms of how quickly they can get this through their parliamentary sessions, and we don't have any timetable or what actually is even proposed in relation to this. So that, I think, was the second question.
Yeah, so first one is, what can I do if the landlord breaches the terms of my lease? And I've got one more saying, if my lease is about to expire, how do I go about extending it?
Okay, in terms of the first question, which the landlord has breached the terms of the lease, again, it depends on what is being breached. There are applications that you can make to the county court for enforcement or its injunction and those kind of things. It just depends on what option. I mean, the options would depend on what the breach is and how much money you've got in terms of rectifying it. The alternative is to, maybe if you've got the other leaseholders on board, or even if it's just you can make maybe an application to the tribunal for the appointment of the manager. I mean, there's a whole variety of options that are available to you. We just probably need to take that conversation offline, depending on the specifics that you've got in that particular case. The last question, I think, was what can I do to extend my lease before it expires? Two things. One, approach the landlord to see whether they're willing to do a voluntary lease extension, or if it's really low, or it's dropped below the 80 years, I would just suggest that you serve a statutory lease extension notice for a 90-year lease extension. But as I just touched upon, you won't be able to serve a statutory lease extension notice unless you've held your lease and been registered at the land registry for more than 2 years. Does that?
That is perfect. And you know what? We are bang on time. It's we're done. We're perfect. All so right. Thank you very much indeed for taking the time to join us today. I think that session was really useful, really good. Now we've got our final day tomorrow, so we will be covering residential fire update and considering costs on the recovery, and we'll also be talking about preparing for building safety reform. So we've got Cassandra Zanelli joining us, and also Dr. Sean Lundy. So we hope to see you tomorrow. Thank you very much for joining us today.